Well, thank you for joining us this evening. I am Jennifer Dye. I'm a librarian at Detroit Public Library. We've had a strong program with the League of Women Voters Detroit since September of 2020. We present on issues of concern to Michigan voters about 10 months of the year. You were all brought into this program muted. Please put any questions into the chat. Ruth Bullwine will capture these questions and ask them at the presenters at the end of the presentation. And if we have time, we might be able to allow people to unmute at the end to ask questions directly. This is being recorded and it will be made available on DPL's and the Detroit League's websites. Cheryl, are you prepared to speak briefly about the League and the Detroit group?
Sure. Our league, the League of Women Voters Detroit, is a nonprofit, but all the leagues are nonprofit, nonpartisan political organizations with national and state and local components. We're the local. For a century, we have worked to empower voters by informing citizens about local candidates, public policy, and advocacy programs. We encourage active participation in the political process. The League does not endorse or support candidates or political parties. We do conduct candidate forums, register voters, hold informal meetings, and advocate for voters' rights. We work in this area to engage people in Detroit, Hamtramck, and Highland Park in local governance, in decision-making, and in issues of interest. Our membership is open to everyone. We have both men and women, and we have people, young people down to 16 years of age. We seek diversity, equity, and inclusion in all our endeavors. So we hope any of you, although I know we already have at least 3 other, besides ourselves, members of the League on, and I'm happy to have them here. And we want you to remember that democracy is not a spectator sport. I will put in the chat how to contact our league, and hope you might do that. So thank you. And we're so happy to have the gentlemen here that are here to talk about this issue. So thank them. I thank you.
Thank you.
Thank you, Cheryl. Tonight, our speakers are Dr. Orville Vernon Burton, Judge Matthew J. Perry, Professor of History at Clemson University, and many more citations, positions, and Armand Derfner, Esquire, a longtime civil rights lawyer. They partnered on the volume Justice Deferred, Race in the Supreme Court, which was published in 2021 by Harvard University Press. For the librarians here in the program, neither Ingrams nor Baker and Taylor listed as available, but our presenters have given me a contact to request copies directly. The paperback version is due out in May. If you want information for ordering the hardbound version, please email me at jdye, D-Y-E, at detroitpubliclibrary.org. As a recognized authority on race relations, Dr. Burton is often called upon as an expert witness in discrimination and voting rights cases throughout the United States. And Armand Derfner is a graduate of Princeton University and Yale Law School. He has been practicing constitutional and civil rights law for 60 years in Charleston, Mississippi, Washington, D.C., and elsewhere. He has specialized in protecting the right to vote, especially helping to shape the Voting Rights Act. And gentlemen, if you are prepared to present, please do so.
One of the things we talk about.
I'm sorry. Patrick Rose has volunteered to ask the first few questions, and I totally forgot about that.
I was hoping that Armand and Dr. Burton could introduce the book and the main arguments in the book and why they wrote it, how they came to write it together and how it was born of a friendship that was evolving out of work that they did in the Voting Rights Act area and in the civil rights arena in the U.S. Supreme Court all the way back to 1980. The story of how the book came to be and what the reasons for the book are and the broad outlines of the arguments in the book. I would love to hear from both of them.
Sure. Armand, you want to start or me? Either way.
Go ahead. Go ahead, Vernon.
Are you sure? This was really Armand's idea, but we really believe that a race is America's most salient topic. And I would argue, particularly at this moment, the Supreme Court is a very close second. So what we have done is a history of race in the United States before there was United States through the confirmation of Amy Coney Barrett, using the Supreme Court as a lens or a focus, as a way to understand race. And I like to go into a brief, maybe brief is the wrong word because historians tend to talk in 50-minute sentences to go along with the bells in the classroom, but as sort of an apology or explanation. The title of our book, Justice Deferred, Race in the Supreme Court, there's no such thing as race. Geneticists will tell you there's no difference between an Episcopalian and a Baptist, a Ukrainian, an African, or an African-American, and we can go on about the Nome Project, or I like to say, as Lincoln did about his ancient faith, that my mother taught me that we were all created in the image of God, and so we're all alike. And I think that's important to understand. No such thing as race, but one of the things we discovered as we worked through our scholarship, particularly Armand with the cases, which you can talk more about, is how the Supreme Court became responsible for creating something that is real, and that is racism. That is that we define laws that made a group of people and then several different groups of people to have less rights and be treated differently than most white Americans at that time. And the Supreme Court has struggled with this definition as well. And I like to go back to say that in 1790, in the naturalization law, the only people who could become citizens were whites. Then in 1870, during that wonderful, misunderstood, but most important period, I think, of American history, Reconstruction, in 1870, people of African descent were added. That is directly speaking to the Reconstruction Amendments. That's the 13th, 14th, and 15th. And I hope Armand will speak a little bit about that. But over the years, the naturalization laws, citizenship laws were amended so that by 1922, a Mr. Ozawa, who was born in Japan but had long been a resident of the United States, had fought for the United States in World War I, thought that now the naturalization law was worded in such a way that the requirement of being white no longer applied to people wanting to become naturalized citizens like himself. So it went all the way to the Supreme Court, who agreed that the wording might be interpreted that way, but clearly the meaning and purpose of the law was such that white remained a requirement. But as often, hopefully we'll have time to talk about, as in some of the more notorious cases, the court wasn't satisfied to stop that. They went on to say that white could not merely be a color because some white people had darker skin than non-white people. We have some pictures in our book or illustrations. I hope you'll take a look at the Lum case in the 1920s in Mississippi to give you a good example of that. So they said that white really meant Caucasian and that Mr. Ozawa was not Caucasian and not eligible to apply for U.S. citizenship. So the very next year, that is 1923, a case involved Mr. Thine, whose ancestry went back to the Caucasus Mountains region of Europe. That is, he was genuinely a real Caucasian, but he was from India and had brown skin. So the court tried for a while to provide some rationale for his decision, but finally decided that Caucasian really meant white. And it's fun to struggle through that. But the Virginia judge who convicted Richard and Mildred Loving of what they called unlawful miscegnation said, quote, Almighty God created the races, white, black, yellow, Malay, and red, and he placed them on separate continents. He's therefore ruled that God, and I quote, did not intend for the races to mix. Well, the Supreme Court has dealt with issues involving all these groups, and that's what Armand and I did from the 17th century through 2021. We tried to cover slavery, its aftermath, Reconstruction, Jim Crow, its dismantling, modern day problems, including criminal justice, voting, affirmative action. Armand, why don't you take it from there, me giving a little bit of historical context and some of my favorite issues.
Okay. We always say, Vernon has said this, and I agree 100%, that this book could not have been written by a historian alone or by a legal scholar, which I don't necessarily count myself, alone. It had to be written by both. What we did, people tend to think, well, there was a Supreme Court case then and then another Supreme Court case, and it's a great big black box to most people. We tried to take the entire flow of America's history. People think, a lot of people, especially from my generation, tend to think of the Supreme Court as the citadel. At least we used to. It's the institution that ended segregation, protects the First Amendment, fair trials, the right to vote. But in fact, as we learned and showed here, that image comes from a short period in the court's history, from roughly let's say the 1930s to about the 1970s. Let's say 40 years out of this nation's 225-year history. Before that time, before the 1930s, the court spent most of its time attacking, destroying, or ignoring the rights, especially in the area of race. And since the 1970s, it's maybe not quite as bad as the earlier period, but the court has done a lot more retreating than advancing in the area of race. So what we tried to do was, in a very readable way, we focused a lot on trying to make this a readable book. And frankly, our wives were mainly responsible there because they said we had to write this book in the English language. But we tried to make it stream and show how the times changed, the court changed. Some things were emphasized, other things were de-emphasized, and it gave us a picture of what has happened from the earliest days to today. That's what we tried to do, and I hope we've succeeded.
I will add, Patrick, how we came to write this book. People will ask us, well, when did you start this book? Well, in 1980, it's not unsimilar to the crisis that the civil rights community finds itself in now, with the court ruling on various things like the Voting Rights Act, on affirmative action in ways, and making it, as we lay out, we think clearly in the book, particularly the last 30 years of the court, undermining what we call the second Reconstruction of the civil rights movement, as the first Reconstruction was undermined during an earlier period that we think of as Jim Crow. But in 1980, in a case called Mobile versus Bolden, the Supreme Court decided that it didn't matter that a law discriminated, that it had a discriminatory effect. That is, in this case, it was a voting rights case. And that just because 40% of Mobile, Alabama could never elect in an at-large election a representative of his choice. It didn't say it had to be a black representative, but a representative of his choice. It didn't matter. You had to show that the stakeholders, that is, the policymakers who instituted that law, intended for that law to discriminate. And we have a whole chapter that I'm pretty proud of. Armand and I worked on a war of words, intent and purpose and effect. So smart lawyers like Armand, who was very active, having worked so much in Mississippi earlier at that time with the Voting Rights Act, and others, knew that historians' job was to get at motivation, to get at intent, and had social science methodology and training as to how to get to intent. So they enlisted historians And that actually went sort of by the wayside later, because Armand was instrumental as much as anyone in getting the voting rights renewed in 1982 and strengthened in a way that said it could be the purpose or effect. But most attorneys like having a good second arrow in their quiver, so they would try to do both. But I remember one of the newspapers, maybe from Birmingham or somewhere, said, "What are we going to do? Have the attorneys dig up the people who made that law and open their coffin and ask them, did you intend to discriminate?" So that was sort of the beginning. And Armand and I was asked to get involved in a case to show the intent and the history of discrimination. And we sort of started arguing about these issues for a very, very long time. And when I say argue, we really argued about what mattered and what didn't and how you'd go about it and things like that. But that was the beginning of a book. I did not know it. Later, Armand is teaching in a college of law, and he's done a case book and decides to do a book and asked me to join him. And I am so glad he did, because for years, since 1980, I had written so many reports that no one ever saw but some justice's clerk, and probably thrown them in the trash can or some file cabinet. But I finally got to take what had been what I was doing at nighttime, all this expert witness reports and the work and things I learned there, instead of writing just about the Civil War and Reconstruction, civil rights movement in my history teaching job. And I like to say, out of Casablanca, that was the beginning of a beautiful friendship that continues today. I'm so honored to have worked with Armand as well, one of the greatest civil rights lawyers of all time.
Okay, cut the malarkey. I'll just say one other thing. We have been talking about this, as Vernon says, since 1980, and there came a time in 2015 when we were both at a conference, and we're in a conversation, and I think a young woman graduate student who'd been working with Vernon said to us, "Look, I've been hearing you guys talk about this for years and years. Why don't you either write the damn book or stop talking about it? I'm tired of just talk. Get it done." So we actually owed the writing of the book to that young woman.
Yeah, to Alexandra, who was my research assistant here at Clemson. Is that good enough? We can go on forever, but
Yeah.
you have questions, Patrick.
I'll mention one more thing, unless you want to break in.
No, go ahead.
One of the things Vernon has talked about, how the involvement of a lawyer has made a lot of difference. In the same way, the involvement of a historian has helped us flesh this out in a way that shows how the past informs the present. And I'll give just two examples that people might not think of. People think of the Reconstruction as a time when there was a noble experiment and then it didn't work out. People also think of, at a different time, in a different way, of the desegregation crises in the 1950s and 60s. Well, those are really connected, because a large part of the reason that Reconstruction did not work was that Congress had passed many enforcement statutes designed to really protect the newly freed slaves and to end violence. Use of those laws in the 1870s basically drove the Klan out of South Carolina. In 1 year, there were 1,200 federal criminal prosecutions, but the Supreme Court threw them out one after another. Well, fast forward to the 1950s, you had riots and violent demonstrations against, like the kids trying to go to the high school in Little Rock, and federal agents couldn't do anything. They had to stand by and watch, because the laws that would have allowed them to enforce the Constitution and protect people had been thrown out by the Supreme Court in the 1870s and 1880s. Another quick example has to do with affirmative action. We think of affirmative action as something that started, it goes back to the late 1970s, the Bakke case. And up to the Harvard University of North Carolina case just a few months ago. But that really wasn't the start. In the 40 years before that time, there had been in this country the biggest affirmative action program in the history of the planet Earth from 1930s to 1970s, and it was for white people. It was a creation of home financing, billions and billions of dollars spent into creating suburbs that were almost entirely white. The FHA had racial guidelines in it. There was redlining. Laws were passed like Social Security, unemployment compensation that covered white people, did not cover black people. 35 million families, almost all white, were put in homes that didn't have homes before. And the Hill-Burton Act created an updated version of segregated healthcare throughout the South. So we had 40 years of affirmative action for white people leading up to the 70s. Nobody thinks about that, and they think that the affirmative action issues of today grew out of nowhere. So those are a couple of examples of where the historian's perspective enabled the legal analysis to have some bones, have some meat on the bones.
Yeah, and as Armand figured out,
Excuse me, please. This is Jennifer. Armand, people are having difficulty understanding your words. Can you talk more directly into your mic, please?
Okay.
Armand, can you use your Southern accent? They're not having any problem understanding me.
Okay.
This is a first. I wanted to add what Armand said, of course, as we see how Congress is now, people forget how powerful the Southern congressmen were. So to give the example of this, when they passed Social Security, they didn't say we're omitting black people. They just said farm workers, farm laborers aren't included, domestic workers. Well, these are the only jobs that were pretty much available in the former Confederacy for African Americans. And I hope Armand will talk a little bit about the amendments, because one of the theses of the book is the 13th, 14th, and 15th Amendment, particularly our belief that the 13th Amendment was not for a one time of freeing the former slaves to address Judge Toney's ridiculous and probably the most infamous rule in the Supreme Court history, though I do think the gutting of the Voting Rights Act is pushing it pretty hard in 2013, but that it is a continuing commitment to, as it was interpreted and understood, and judges wrote about it, to end the badges of slavery. And Armand got me to doing a new thing with students I just did in class today. Asked, when did the Civil War end? And some will say, well, with the Emancipation Proclamation. Some say the end of the Civil War. And some say, in fact, with the 13th Amendment. But as Armand looked at it very carefully, and I think he's right, we would argue maybe it's 1968 with a court case that comes back to the 13th Amendment and says it's still there to end those badges of slavery. And one of the things we have called out in the book is that particularly originalist or textualist on the court, they like to be originalists or textualists, they say. Well, they read the First and Second Amendment just as narrowly as broadly, as it can be read, but they treat the 13th and 14th and 15th Amendment as if it's not part of the Constitution and are reading it now as narrowly as they possibly can. So we're also calling for consistency if you're going to be an originalist or a textualist. Armand, do you want to talk more about the 13th Amendment and the power of the 13th Amendment and what's happened to the 14th and 15th?
Well, I'll just say one thing. Maybe we could have Patrick join in here for a second. But going back to the affirmative action cases, and can people hear me now? Is it better? Okay. Going back to the affirmative action cases, those were decided solely on the basis of the 14th Amendment, and specifically part of the 14th Amendment that said equal protection. And so presumably that means equal protection for everybody. But why didn't they also think about the 13th Amendment which was clearly designed, spoken this way, written this way, and designed to enfranchise and free a race and uplift a race. Clearly, the 13th Amendment and the 13th, 14th, and 15th were all designed. The Supreme Court, in the very first case after those amendments were adopted, the very first important case called Slaughterhouse, said at length, it's familiar history that these amendments would not have been passed but for the one overriding purpose to elevate a race, to bring a race out of the depths and bring it into equality. And why the Supreme Court would decide cases based on taking the 14th Amendment, taking history out of it, taking the 13th Amendment out, leaving the 15th Amendment, that's, as Vernon says, you're not a very good originalist if what you do with the original document is take a few words out of it here and there and leave the rest out. I can pick words out of anywhere and pick out the words that lead me to a result I would like, but that's not what you ought to be doing if you're a judge, especially if you think you're an originalist.
Armand and Dr. Burton, if we could just go back to the beginning in 2 quick steps. I've heard you talk about slavery at the very beginning of the settlement of the continent back in the early 1600s and how it became racialized, and Bacon's Rebellion and the introduction of the Black Codes, and then how slavery grew because of the importation of slaves all the way up to the time of the founding. And my next question is going to be how the framers dealt with this question and whether the Constitution was race neutral or whether it had a compromise with slave owners, especially from South Carolina, which was designed to preserve a union by protecting slavery and go through the institutions in the Constitution that protected slavery and allowed it to grow up till when importing slaves was banned. And then after that time, slavery grew even more. And then my third set of questions will have to do with what happened in the 1840s and 50s. But it seems to me relevant that we have this debate in the country right now about whether the nation was founded on slavery or why slavery was so strongly able to develop as an economic institution with legal protections to the point where on the eve of the Civil War, according to Thomas Piketty, over 60%, some say 2/3 of the wealth of the country was derived either directly or indirectly from slavery. And I just thought you could address that to then go into what a revolution it was to ban slavery and to create this new birth of freedom.
Let me start with just a couple of summary observations. Then I'd really like to hear Vernon talk about some of those things. But number one, we have had, if you count a generation as 25 years, we had a dozen generations, 300 years from the mid-1600s to the mid-1900s of slavery and Jim Crow. That's 300 years, 12 generations of people passing on to their children the same values, which were that one group of people is better than another group of people, and making laws to clamp that in and nail it in. We've only had 2 generations, really, since the Civil Rights Act, the Voting Rights Act, to try to overcome it. So in one sense, it's not surprising that we're still having problems. You don't overcome a dozen generations of heritage in 2 generations. We are still, and we are now trying to overcome it. And naturally, there's going to be pros and cons. And we are now, in a sense, paying the price for what 12 generations did to us. Vernon, and I'll just say one more thing on that. Even with changes, even with a lessening of discrimination, the vestiges of that period remain. I'll give you some specific figures. With the decline, and I think there really has been a decline of discrimination, certainly overt discrimination. Now, Black people and white people in similar situations, the gap in income is probably about 1.5 to 1. That is, the white person is making not twice as much, but more than the Black person, say 1.5 times as much. But in terms of net worth, family wealth, what the resources are that you have to draw on, the difference is 10 to 1. 10 to 1. And those are figures that the Federal Reserve Board has done over the years. 10 to 1. 2/3 of that gap is what's called intergenerational transfers. That is, all the assets, not just what the money you get in a will, but all the assets that I get from my parents or uncles and grandparents who came before me. So that shows you how far we have to go. And yes, I think we've come a long way in just 2 generations, but it's pretty hard to overcome that much in that short a time.
And that 10 to 1 ratio has been consistent for about as long as they've been doing those statistics. It's pretty amazing, despite the better numbers in terms of the actual wage gaps and things. It's just very hard to make up that intergenerational wealth. And I want to add, as a good example of that, what Armand was talking about, and that is how my father-in-law was able to buy a home in Illinois as a veteran with the Veterans Loan Project. And that house appreciated in wealth. He was able to send his 4 children to college. Now, Black veterans had the same rights, except for one problem. The one major problem was the people who ran those programs in the former Confederacy were all whites, and many of them were not sympathetic at all. But you have what were covenants that we talk about that did not allow Black people to buy in those areas. And some of those covenants go back and included Jews and every other sort of group of non-whites. But you also had federal redlining rules about who could buy where. And so homes, East St. Louis is my best example, or maybe the Precinct 9 or Ward 9 in New Orleans when you had the hurricane there. It is in those areas where most Black people's homes and veterans are able to buy, and they could not appreciate in value. That's just one example. If you get into the specifics, which we do in the book, it really makes a difference to understand how this wealth has come. And, Patrick, it's a big debate about the Constitution. We let people debate it in the book, from Frederick Douglass, who goes from one to another view on it, to Thurgood Marshall, who thought that the potential was there to change it. But of course, slavery is not mentioned in the Constitution until the 13th Amendment, when it's banned. So they get away from the word, which tells you something. And then there's these compromises to get particularly South Carolina and Georgia and other states for the Confederacy to be able to join and have this union. And it's why Lincoln felt that even as a war measure, that is, sort of smartly, it was actually General Butler during the Civil War, because Roger Taney's famous Dred Scott decision, the case for Ms. and Mr. Dred Scott from Missouri, had said that people were property. So Butler suggested that when African Americans ran away and came to Union lines, that they were property, then they could be confiscated and not go back to help the Confederacy. And that's how you get on this path to confiscate, using, we don't think of it, but using this terrible law as a way to keep African Americans from going back to work on farms and support enslaved on and the Confederacy. So it's debated. My argument is, which you've heard before, is that it was Abraham Lincoln who said if he would be remembered for anything, it was for the Emancipation Proclamation. But I think what he really did, starting with the Emancipation Proclamation, is took our basically guiding principles. That is, he took our mission statement, the Declaration of Independence, and put it in our rule book, the Constitution. He changed that Constitution from one that gave all the rights, that is, those first 10 amendments, reserved to the states, and now that 13th and 14th and 15th Amendment, I hope we get Armand to talk about a little bit, that's so important today, gave Congress a right to enforce that black people were free and that had been enslaved, and that black codes were not fair, that in fact that they had the equal rights of white people in the former Confederacy, and that they had the right to vote. Of course, all that gets contested and is being contested again. And then those rights are expanded to other people. If you think about it, we do a lot on what I call Briggs v. Elliott, but we have to call it Brown v. Board in the book because that's what people know it by. But it really begins in South Carolina. And that comes right out of the 13th, 14th, and 15th Amendment. And that leads us into the 1964 Civil Rights Act, which gives rights to everyone, Native Americans, the Japanese, all these different groups, old people like me, those that are disabled, those that might have different gender identifications. Is so important. And it all goes back to making that Constitution come in line with the Declaration of Independence, ever how imperfect it was. But there is a big debate, even among scholars today, but no one can deny that so much wealth, not all the wealth, but so much wealth was built upon slavery. And so if you look at the census of 1860 and 1850, the wealthiest people in America were not railroad or large capitalists, or it was the people who enslaved people in the South. And so that gives you an idea, and particularly that decade of 1850 to 1860, slavery was expanding or wanting to expand. That's why Lincoln and the Republicans drew the line at the expansion of slavery. And with the Dred Scott decision, which undid that compromise, which had been there from the Missouri Compromise, and Lincoln and other Republicans were upset because it said now that they could insist that slavery could be in Illinois or Michigan or any other state since the compromise was gone. Does that get at what you're
yes, it
about?
does.
And you're sort of, I think, hinting around the 1619 project a little bit. Sounds to me like
I'm thinking about Michael Klarman's The
Okay,
Framers
yeah.
too, and he talks about the Electoral College as a compromise for slavery to protect slave owners, the 2/3 of a person over representation of the slave power, the structure of the Senate, the protection of the slave trade and making it unamendable, which violates any common sense idea of a constitution, the filibuster, the gag rule in the Senate, all of these things that stay with us today that we're still dealing with. We're dealing with the filibuster, the Electoral College. And I'm just wondering the degree to which we have to understand that those are part of the legacy of slavery baked into the structure of our national government.
Yeah, and to ignore it is silly. And I think we talk about all of those in the book. One of the things that's pretty amazing to see how we change the law, English common law. You might remember in the beginning, we talk about in England, of course, the child of an enslaved person followed the status of the father. Why do you think they changed it in the United States? So that it followed the status of the mother. And that gives you some hints at how we have used our laws to reinforce slavery and to reinforce the rights of people who owned other people, or at least thought they did. In fact, one of the things to jump forward, I did this for you before. This is what I said if I had the power. I love the first illustration in our book. I don't know if people can't see it, tell me, but this is Thurgood Marshall getting off the Silver Meteor in Charleston, South Carolina, to argue what is Briggs v. Elliott that people call Brown v. Board. And it's about the time he's almost lynched in Florida. He barely gets out of Florida. And there's a quote that goes with this picture, which was taken by a friend of Armand's and mine, who was 13 or 14 years old at the time, the great chronicler of the civil rights movement in South Carolina. It's named Cecil Williams. There's a museum now. And what Thurgood Marshall says that I put there with that picture, I love, he said, sometimes I get tired of saving white people's soul. And we think of the civil rights movement about bettering the lives of African Americans in some way. But this, what you're asking is this original sin, as we call it often as historians, of slavery and racism. How has that also corrupted the souls of white people? What does it mean for kids that grew up in 96 South Carolina like I did to think that you are superior to other groups of people? And if that's not still there in our society, try to explain what happened to Ahmaud Arbery when he's jogging through a white neighborhood in Georgia and three men think they have the right to stop him and kill him if he doesn't comply with them ordering him to stop. That goes back to slave patrols. All of this is full of our history and the laws that are there. So many of the laws that are still there reflect these compromises that were given at the time.
I have
As you know, the 3/5 compromise was a compromise to keep the former Confederate states or enslaved states from wanting to count them as entire peoples for population purposes to get more votes. So the 3/5 clause is to keep the people who own other people, the enslaved people, from counting as a full representative like a wife would. Even though a wife couldn't vote, they were arguing, well, enslaved people can't vote, but their property like a wife is, so they should count as a person.
I was hoping you could talk about the tremendous successes of Reconstruction by just walking us through from when President Lincoln's on the White House lawn and he says that he's going to grant the right to vote to freed slaves and give them equal rights as citizens. And John Wilkes Booth and the conspirators say that's the last speech he will ever give. And of course, he's shot on April 10th and dies on Good Friday. And then for a year, we have this process of a former slave owner from a slave state and President Andrew Johnson, without Congress in session, essentially allowing what continued to be conflict in the South. The war didn't really end. And all of these people come and ask for presidential pardons, and then black codes are put in place, and a whole system of kind of a new form of slavery is put in place. And Congress comes back and will not seat the old Confederates and is having none of this, and passes the 13th Amendment, and it's ratified. And then we get the 14th Amendment and the right to vote in Freedom Summer, and 80% of freed slaves in the South vote in Freedom Summer. And we have a election with fusion governments, 7 of the old Confederate states that have multiracial governments. Can you just talk about some of the successes that grew out of that, the parts of Reconstruction that were really successful, building schools, rebuilding the South, and some of the things that came out of this new birth of freedom before we get into how it was thwarted?
Sure, we could talk forever. As you know, I think Reconstruction is the most important, at least understood period in our history. And also this mythology, particularly of the Old South and the glorification of it, is just corrupted how people have understood Reconstruction. When I first started testifying, even in California, I had one time an attorney defending a school board saying, well, we can't have a Reconstruction like you did in the South, with this terrible mythology. It was the most progressive period, we think. And I think Armand and I did a good job of showing the contingency and the difference it made having Lincoln there. And I'll just say a little bit because I want Armand to talk a little more about this. But when Lincoln was assassinated, he had moved, the country far away. And when he says that he is going to that people who fought, referring to black soldiers, are entitled to the vote, and some others as well, it's when John Wilkes Booth hears him, and he says that will be the last speech he ever makes. So Lincoln was killed for advocating for the franchise for black people, like a lot of other martyrs who have died arguing that black people have the right to vote. That's one of the themes of the book, the centrality of the vote at that time. Just one quick example. Robert Smalls, a great Civil War hero who Lincoln met with after he stole the planter and sailed it out on the nose of the Confederacy, risking his life, his men's life, and their families. He had them on there. And to give you an idea of how far we are from slavery, on that ship was his daughter Lydia, who did not die to 1959. If you think we're a long way from slavery, I can give you example after example of that. She was an enslaved child on the ship, meets with Lincoln. Lincoln asked him, why would you risk your life like that? And more than his life, he would have been horribly tortured before finally being killed if he'd have been caught. He gives Lincoln a one-word answer: freedom. And that is what Lincoln echoes not long after that. He's meeting with Lincoln because they want to convince Lincoln to use black troops. And he's a great example in the war. Let blacks fight in the war, because what he's done. So then when Lincoln gives his Gettysburg Address, he echoes that, called the new birth of freedom. Then in the second inaugural, once again, he gives that second of his greatest speeches. And he talks about how we're going to support the widows and children of those soldiers who have fought for the war. And who is he talking about? Not just Union whites, black. And it's the first time he's saying that black marriages are legal. They've been, by the law, de jure illegal in the South. Another one of those laws that are there that are so horrible. And talks again there about black freedom. When he dies, the cabinet is split evenly on whether to give black people the vote and make the Confederate states, when they come back in the Union, accepted as part of the 13th Amendment. And this is after Lincoln has said what he is going to do. But Andrew Johnson puts in a grandfather clause for his home birth state of North Carolina, the first one he oversees, and says that if you weren't voting in 1860 or 1864, then you cannot vote, or if your grandparent didn't vote, and that becomes a model. Armand, you want to pick it up there? I was going to just mention Smalls in South Carolina is the person who in the 1868 Constitutional Convention introduces the bill that becomes part of the Constitution that says that South Carolina will be the first state to have public education for every child, black and white. So we don't usually think of South Carolina leading in education, but under Reconstruction it did. And in many, many other areas of progressive legislation, rights for women and other things. And I like to remind people, if Reconstruction was so bad in a democracy, why did it take a counter-revolution, a terrorist organization, a paramilitary group of many former Confederates in South Carolina and in Louisiana, Mississippi, led by former generals in the Confederacy, to overthrow a legitimately elected interracial government? We had a coup d'etat in America, in the United States, that people have not understood. They've taken it and given it a word that is a beautiful religious word with such, and call it redemption. They've just figured out how to use these words so well from way back that I absolutely hate that I do. Armand, you should take it now. Talk to me.
I was going to say that one of the things we tried to do in the book is to highlight all the myths, all the mythology that we have lived under. A big myth, of course, is the myth that Reconstruction was like birth of a nation, with the heroic Klan saving people from monsters. As late as the 1940s, there were justices on the Supreme Court who actually said that. There's an opinion in which several justices, fortunately, they did not prevail, but they said it is familiar history that these laws, the Reconstruction laws, were part of that vengeful spirit that embittered the Reconstruction period. Well, that's what they learned from the Dunning School, which was a group of historians around 1900, and that was what everybody believed. It's the birth of a nation gone with the wind analysis of history, and unfortunately, people, including the Supreme Court, fell for it and bought it. Another myth that people bought all the time was the notion that race discrimination happened by itself. And what we tried to show was how the government and law, the states, including northern states, as well as the federal government, fed that and insisted on it. There was the Supreme Court of Massachusetts, of all places, back in the 19th century, said, well, discrimination does not come from the law and cannot be overcome by the law. Absolutely false. But we have justices today who believe the same thing. Justice Rehnquist, who became chief, I guess this was when he was chief justice, was a segregationist before he got on the court. He never changed his mind. He remained a segregationist his whole life. And in one of his famous opinions, he said, an opinion about white flight. He said, well, segregation has nothing to do with white flight. Unbelievable. Justice Thomas says, well, when people formed the suburbs, that was purely individual choice. Yet the suburbs were created by government financing, by government laws enforcing restrictive covenants. The law has been at the center of our divided society. Now we're trying to use the law to overcome it. People are still resisting, but we are in the shape we're in today because the law for 200 and 300 years sent us there. And Vernon mentioned this one great example about how the colonists carefully reversed the one piece of English law that stood in the way. The question of how would a child be judged? In England, the child status went with the father. Here, that would have made a lot of slave women's children free because a lot of those children came from the slave master raping the slave. So we quote George Orwell in the introduction, I think, about how we are able, society is able to turn falsity into the seeming truth or vice versa and decide on what is the story we want to tell. What we tried to do in this book is tell the story as it really happened.
And with Rehnquist, I can't help but say that, you know, when they were looking at Briggs v. Elliott, that you folks call Brown v. Board, that he was the clerk for Justice Jackson. And of course, he writes this rather now infamous note saying that though it may not be popular, that the correct ruling by Plessy v. Ferguson is separate but equal. And of course, then you have Judge Roberts, who clerked for Justice Rehnquist. And you know how I feel about what he did with the Voting Rights Act. We lay that out clearly in the book. And it's probably worth me saying the three little examples I give that Armand wouldn't let me put in the book because he's reading something now. He can't hear me, and I can do it. Okay. I'll be in trouble again. But
so, Dr. Burton, can I just ask a follow-up? We have a question in the chat that goes directly to what you were describing regarding Abraham Lincoln. It comes from Ayani, and she says, would Abraham Lincoln's stance on Black people in America, particularly his wish to send all freed Black people to Liberia, change the intention of the Emancipation Proclamation? And does this movement have an effect on it? On the impact of the Emancipation Proclamation and how the Supreme Court came to view the proclamation or the 13th, 14th, and 15th Amendments. And I think the question's getting at what really was the vision that Lincoln and the Reconstruction Congress had. Was it really about creating a society of equality under law and true equal opportunity? I think that's really what the question's getting at. Given the history.
Yeah, I think you have to break it down because he was part of the colonization society. He also was, in fact, did arrange for some people to be sent. I believe it was somewhere in Latin America, Brazil, somewhere like that. But when he found out they didn't like it, want to come back, he also used a government thing to bring them back. Lincoln was evolving on race, and a lot of people forget that there were a number of Black leaders who were also colonizers because they saw, as Lincoln did, the racism was a real thing, had become a real thing in America, and trying to struggle with that problem. But I would argue the 13th and 14th and 15th Amendment was a result of the idealism that came out of the Civil War, including Lincoln's progression on the issue of race. And you heard me yesterday on that, Patrick, on another thing. I don't want to take all that time to explain it, but I do think that as Lincoln evolved, by the end, he is leading the nation to a better place on race and has committed himself to citizenship and the vote, what Frederick Douglass called manhood, that is the vote. Of course, women didn't vote, but to being a citizen with equal rights, the same rights as white people. And that's exactly what the 13th and 14th and 15th Amendments say, that people are, it is about the rights, the legal rights they have. It's about not being excluded. It's not necessarily about integration. It's not even clear that Black people want integration, but they want that choice, I think. And that choice is not to be excluded from the same rights that white people have. And that's what that Congress is doing. I love the quote that we have in the book that comes from the Chicago, is it the Tribune? I believe it was, wasn't it, Armand?
Yeah.
Which says when they see what, after Lincoln's death, what whites in the Mississippi and other places are doing. And he said, we want you to know that we will raise an army again and come down and make a, what is it, a mud puddle, frog pond out of the whites in the South for what you're doing, because Black people had helped win that war. Lincoln makes that clear. He says it's because of Black soldiers that we're able to win this war, and we owe them because of that. That's what John Wilkes Booth understood, and that's why he killed him.
I wanted to ask a follow-up of Armand. You talked about housing segregation, and I wondered if you could mention how the Equal Protection Clause came to help us with discriminatory enforcement in the San Francisco case with the Chinese laundries. And then the Supreme Court had a chance to deal with this express discrimination in New York City with the building of Stuyvesant Town, where they tore down 18 by 10 blocks, and 45% of the homes were African-American and Latino, Puerto Rican, and they built a whole new subdivision, and it was tax subsidized. So the federal government's paying $50 million to MetLife, one of the wealthiest corporations in the country, and they make it only for whites. And somehow this was allowed to stand, and this was in 1950. Can you tell us about this case, the Dorsey case, and can you tell us where it fits in your argument about why the suburbs didn't segregate themselves?
Yeah, it's an example of how the right takes a long time to catch up with the wrong. There had been housing segregation throughout the North that the Supreme Court allowed and fostered by saying for many years that restrictive covenants were perfectly okay. When the Supreme Court finally said restrictive covenants were okay, well, then it was still a problem of what is the private sector doing? And the private sector naturally has never counted on just private resources. Private sector has always wanted government resources. So by 1950, Metropolitan Life Insurance Company was building this gigantic project that Patrick has referred to, that many of you know about, covers many blocks in New York City, but it wasn't private. Metropolitan Life got huge tax incentives. The city condemned the property, created the parcel, and basically handed it to Metropolitan Life with a 25-year tax stabilization. What they call the stabilization means taxes are not going up for 25 years. So it was, but a case went to the U.S. Supreme Court in 1950, and the court said it was not going to take it and was not going to touch the issue of what is state action. So that kind of private, so-called private enterprise went on for many years, meaning that by the time we recognized that state action was a very pervasive thing, including a lot of what we thought was private action, the die had really been cast. And so we are deeper in today than we might have been if we had recognized earlier. So it's always been a project of trying to catch up. And that's why I say 300 years, 12 generations is a lot to catch up. And that's our job today.
Tell them about the contingency of Frank Murphy and the former governor that died. I mean, the book is.
That's right. That's right.
This book is filled with what historians we now call contingent, what ifs, because we get depressed too easily. Particularly when we were writing this book, we got depressed quite often, particularly at the end. But I kept wanting to remind Armand that things do happen.
Yeah.
That we don't expect.
Talked about the Stuyvesant Town case came to the Supreme Court in 1949. And under the rules of the Supreme Court, if you have 4 justices who want to take a case, you probably know about that now from watching TV about the various Trump cases, four justices get the Supreme Court to take the case. If the court had taken this case, they would not have upheld a white-only Stuyvesant Town. I'm confident they would not have been able to say that. But by ducking the case, they were able to avoid the issue. Well, how did they duck the case? When the case came there in 1949, there were clearly 4 justices who wanted to take the case. One of them was former Governor Frank Murphy of Michigan, former governor. Not only that, he'd been judge of the Recorder's Court in Detroit. He was one of the justices. There were 3 others who wanted to take the case. Suddenly, in the middle of 1949, in the summer, within the space of 2 months, Justice Murphy died, just in his 50s, and another Midwestern justice, Justice Wiley Rutledge, who came from Iowa, he suddenly died also. He was also in his 50s. Their dying made it possible for the Supreme Court to duck the case, with consequences that went on for many years. It was not till 1968, Vernon mentioned this earlier.
Meyer case.
In the
Meyer case.
The Mayor housing involving a St. Louis suburb, that the Supreme Court said, the 13th Amendment. The 13th Amendment and the Civil Rights Act of 1866 make private contracts that involve racial discrimination. Even private contracts are unconstitutional and illegal if they call for race discrimination. So the problem is we've been playing catch up for many years, decades, and even centuries. And that's why we are here, all of you, all of us, all the people of this country, trying to catch up for what happened earlier. Not that our ancestors were more blameworthy. I don't know that if we'd been plunked down in 1825 in South Carolina or Missouri or wherever, I don't know that we might have done differently. But we are here to pick up the pieces, and I think this book is designed to help people realize where we were. As historians like to say, you can't tell where you're going if you don't know where you've been.
You might mention that Murphy was the dissenter, of course, in the Japanese internment case.
Right.
So it gives you an idea of where he was. He was a very good and unsung justice, I think, in terms of trying to do what was right for the United States and for everyone.
I want to ask you 2 questions about the Detroit area and the impact of the Supreme Court on segregation in public education. I was wondering if you were to look back upon Brown versus Board of Education from the vantage point of today, could you help us understand how it is that integration was ruled in Brown v. Board to be necessary to implement the Equal Protection Clause, that separate but equal was no longer acceptable, and in the year after, their decision said you have all deliberate speed to implement this remedy, and of course, massive resistance resulted in the closure of many, many schools across the South. In Michigan, we had a constitutional amendment in 1972 to bus all the dollars to private schools, which was our own form of massive resistance. It was defeated by voters not once, but twice. It's not like we didn't have massive resistance. By 1964, my understanding is that the degree of integration that had occurred in the first 10 years after Brown was not significant. And of course, we get to the point where we have a federal judge in Detroit who orders cross-district busing. And then by 5-4 in Milliken v. Bradley, that is overturned. And we are now sitting here in a position where the degree of segregation in the public schools is greater than the segregation at the time of Brown v. Board. So How do we understand that? And in particular, since Archibald Cox worked up a case in Milliken v. Bradley to show systematic discrimination in how monies were allocated to schools by the state of Michigan, why wasn't Milliken v. Bradley about the dollars? And why isn't there a fundamental right to education?
Well,
Well, before Armand answers, let me just say one thing, because this whole Brown v. Board is really Briggs v. Elliott, and these are extraordinary, heroic people. They actually were not asking for integration. I want to say one other thing too is we've never had integration. So when people say integration hasn't worked, well, we haven't had it. But what they don't realize is how bad segregation was. It's a South Carolina judge, Judge Waring, who says that per se segregation is inequality. And to understand that, you had to look at what Clarendon County was. This group of parents, most of them lost to everything under the pressure from whites for doing it. They first asked for a school bus. There were 7 or 8, up to 30 school buses for white kids, none for black kids who walked as much as 7 to 14 miles to get to school in the rural South, while a white bus went right by them. So when they wouldn't give them a bus, they bought their own bus and fixed it up and asked for gas. And whites refused to give them the gas money. I've often thought, if white people were a little bit smarter, you might not have ever had these cases or the Civil Rights Act or anything because of this. But I want to set that out because these truly are heroic people that need to be recognized. And I mean, they were the man, the reverend, the preacher who started this, who really is the person that got to go, Reverend J. Delane, was literally driven out of the state. His house was burned down. His church was burned. When the AME church moved him to another city, not because he wanted to go, they made him. Then the head of the White Citizens Council went over there and told him, that's the, didn't use the word, black man that caused all the trouble. What are you going to do about it? This was Lake City. They had literally, under Teddy Roosevelt, shot a black postmaster, killing him and his 2-year-old daughter in his hands as he was burning the house down. They wrote a note to Delane saying, you know what happened to that blank postmaster? Same thing's going to happen to you. And so he went to the police. They told him to mark the car. He took his gun. When they shot at his house, he shot the car so that the police would know it. The police put out a warrant for his attempted murder, his as the murderer, attempting murder. So he is now the felon. He barely escaped South Carolina, goes to New York, moves back to Charlotte. His love of that place in South Carolina was so great. And that's where he dies in early 1970 when there's still a warrant out for his arrest. And these people have never been recognized. Now, Armand, deal with this and mention the Rodriguez case too, because that's so important in all this as well of where we are in education today.
Well, we could go on forever, and it sounds like we probably are, but let me just bring the Detroit back into the picture, because Patrick, you mentioned the Milliken case. There were two Milliken cases, two Milliken versus Bradley cases in the U.S. Supreme Court. It was the first one in the mid-70s, 74, that said you couldn't bus kids, a court could not order kids bused across county lines in Michigan. Put that aside. 3 years later, they have come up with a plan to put more money into the Detroit schools to improve those schools, partly for the kids who were there, the black kids, but also partly for what they called desegregative excellence. In other words, trying to attract kids, white kids who might be in the nearby suburb or in nearby areas, and try to show them that there was some advantage to going to these schools that they might otherwise flee away from, because these schools had either air conditioning or special programs, excellent teachers, etc. So, and the Supreme Court held that it was proper to have a program like that to help desegregate the schools, and that the state should pay for it, because the state had really created the system. Okay, fast forward. one of the reasons we talk in the book about how things have gotten progressively worse, more retreat than advance in recent years, that was 1977. 20 years later, 1996, the same question came up in Kansas City, where the judge had ordered the state to provide additional resources for Kansas City schools, partly in the hope of attracting kids back who had moved to the suburbs or lived nearby, white children who their parents would have some reason to bring them to the schools they had been in before because of what was called desegregative excellence. In other words, give a school something so special that a white kid will want to go there. Well, you know what? The Supreme Court in those 20 years had gotten so much worse that what they approved in 1977, they said, oh, no, you can't do that in 1996. So in a sense, we talk about how things got better during a period from the 30s to the 70s. And since that time, it's been a sort of a backward step, one after another.
And I want to point out a purpose and intent in this. Armand and I were doing a case in the 1980s together. And I found in the Jimmy Burns papers, when they word that they may have to desegregate, that they would have to, I hate to use the word integrate because it was very slow and we didn't get into deliberate speed and all of that. But he writes and says, even though we may lose the case, because of segregation living patterns, we can still maintain pretty much segregated schools by where the people live. So people knew what they were doing. I mean, they'd already planned if they lost, they could use in areas that are large enough, like cities or other areas, the housing patterns as a way to keep the schools segregated.
So I also have a question since, in the aftermath of the George Floyd incident and so many incidents before, we had so many protests. You have discussed the difficulties of suing cities and city police departments over many, many decades. And it wasn't until the Monell case that the Section 1983 Reconstruction statute was able to be used because cities weren't recognized as persons. Can you tell us the story of why it took so long to be able to hold cities and their employees accountable? And also, what is your proposal to deal with the fact that even though you can now sue cities, there is such strong immunity that has been literally invented by the courts that it's in many cases impossible, which gives a license and impunity to too many police officers to engage in conduct for which they cannot be held accountable, that by it's not true in all cases, but in many, many cases, they can't be held accountable because of immunities that the courts have created. And you have a proposal for that. Can you address both of those points?
Let me just say that I made Armand's life miserable because I suggested we do this chapter, which I think is, we both think is important, but to pull it all together, it was not easy, but it's so important.
It all out. The Supreme Congress in 1871 passed something called the Ku Klux Act. It is the same law that is now being used to prosecute the people who invaded the Capitol, because Congress was really perceptive at that time and saw all the evils that were coming along. And frankly, the evils of the 1870s in some ways are the evils of 2020. So one of the provisions was something that gave a person whose rights were violated by state officials the right to sue. But the Supreme Court, in one case after another over the years, has created immunities, this kind of immunity, that kind. So you can't sue this one unless you show a very high level of proof, etc. What we've said is that the way to deal with that is to make cities liable for when the officers do something. It's not necessarily, holding a particular officer for something may not be totally attributable to that officer. For example, in Kentucky, the killing of Breonna Taylor. Yes, it's true, officers came and executed a search warrant and the person at apparently the wrong place, but they were given a search warrant. They were told this is the place to go. So if you try to figure out who's responsible for what, oftentimes it's not one person. And so we've suggested it's the city that ought to be liable for that. And cities can insure themselves. When an employer in private industry, when somebody creates an accident, the employer has to bear the cost. And that's what society in every other situation, private and public, has recognized. That's the way to spread the risk, to solve the problem of accidents and injuries. And it ought to be true with the cities and policemen too.
We have about 11 minutes, and I have two really important questions to ask you both. And the first has to do with ripping off the headlines, and that is what Section 3 of the 14th Amendment has to say about disqualifying the former Confederate officials. I want to know why they got off so easy. They didn't lose their right to vote. They didn't lose their property. They weren't having their heads cut off like in the French Revolution. They weren't imprisoned. There was an attempt to try Jefferson Davis, but in the end, they got 5 or 6 or 7,000 presidential pardons from Andrew Johnson. Then they got a general amnesty in exchange for civil rights, support for civil rights in 1875. And after they got the amnesty, they abused it by fomenting a reign of racial terror. So it seems to me that letting people off the hook and not disqualifying them is rewarded by more impunity and more lawbreaking. So my question is, how can we read the text of the 14th Amendment and understand what was intended by the people who drafted it in Congress to resolve the question of whether President Donald Trump should be disqualified for being involved in an insurrection? What did you have to say about this in your brief? And how do we answer Justice Kagan's question of whether one state at a time gets to make their own decision, or whether this is a decision for the whole country, and once it's decided in one state, it's decided for all states? Can you address whether it's a close question, whether he should be disqualified, and what you had to say in your brief?
Well, Alan Littman and I wrote the brief, so I'm responsible for every word in it. And Armand, I got you to read it, didn't I, Armand? Didn't you read it?
I did.
Read it for me. And it's funny because we said we are not taking any legal question and no political questions. All I did was lay out what people at the time said they were doing about the 14th Amendment and how people understood it at the time. But every headline from the New York Times on down says historians say. Well, it's not historians say. What I wanted to do with that brief is something that's bothered me since, as we talk about how Justice Roberts really invented or by lips and words, got rid of the Voting Rights Act, or going back to Judge Toney, who literally created a false history where even though the dissenters explained that African Americans were citizens and voted at the time of the Constitution, they voted in the enslaved state of North Carolina until after Nat Turner's Rebellion. And then, of course, one that people are very familiar with, fairly egregious, is the overturning of Roe v. Wade, where Judge Alito uses 16th century jurists, one of who hung witches, as the basis of his jurisprudence to say that women have no control over their bodies.
So this is the original. This is the original public meaning where they cast around for words, but you focus on the drafters of the 14th
That's
Amendment
right.
and the words to say that it applies to the president. It's self-implementing. It doesn't require enabling legislation. It doesn't require a conviction.
And that officer that the president is covered during the debate itself. Representative Johnson from Maryland, who was a Democrat and opposing it, said, well, I see the president's not covered. And the drafter of it, one of them said, look, and pointed out to him, and he said, I guess I'm mistaken. Then the president is covered, and no one else questioned it. Andrew Johnson loved to be referred to as chief officer. So there's no question what they intended and that he's covered. The Elena Kagan question is sort of interesting, and I think it puts Justice Roberts, particularly with some of his rulings, in a real bind, because they have been ruling that states have the right to do anything they want to with their elections, it seems to me. And the Russo case makes it very difficult for voting rights, fairness at all. But Armand, you want to speak to that? But yes, the intent, they made it very clear who was covered, why they were doing it. And it changed. Remember, initially, not everyone, but the officers and others could not get the vote. That's why they petitioned until the general amnesty of 1872. But they also said very clearly that the 14th Amendment was for future instances. And they made clear what they considered insurrections, which certainly our January the 6th would have come under. I mean, people are welcome to read the brief. I'm happy to send it to you, Patrick.
So your argument would be that he disqualified himself by engaging in an insurrection. If he claims it wasn't aiding one, he would get a federal court hearing on whether there really was aiding an insurrection.
If I mean, as I read it, he's disqualified. But if Congress wants by 2/3 vote say that he's not, and it's okay, then he can.
But he would get a due process hearing in federal court if he wants to say he never aided an insurrection, and there would be a factual finding on that by the court. And then if Congress disagreed, it could overturn it. But otherwise, it would apply uniformly in all the states.
It would have to, unless you want to cherry pick the Constitution and say that Section 3 of the 14th Amendment, we're going to ignore it. You got to be 35 to run for president.
So Jennifer Granholm was born in Canada. She could complain that she's being disqualified because she's not a citizen of the United States. She was ready, willing, and able to run for president, probably could have gotten on the ticket and might have won, but she never made a big argument that she's disqualified. There's plenty of 29 and 32-year-olds who want to be on, like Pete Buttigieg before he got old enough, and he might complain that he's disqualified.
But those are the rules of the game. It's like when I play tennis, I've got to hit the ball within the bounds. But
so this is the most.
You have a rule. You have a rule of law. But let Armand speak to Elena Kagan. I think that's a good question.
Well, I was going to talk about Jennifer Granholm, who I think should be the president. And I think, it depends. If this is a little bit of a joke, but it depends how you read the words. It doesn't say you have to be a native-born citizen. It says you have to be a natural-born citizen of the United States. Okay? So, as far as I know, Jennifer Granholm was not born by cesarean section, so she was naturally born. She's a citizen.
Here we're playing Macbeth.
All right. So I want to get to what I think is one of the most important, urgent, current questions, and that has to do with the Voting Rights Act. And I'm really interested in why the Voting Rights Act was so important, why it was passed in '65, why prior laws were not sufficient, why the adoption of the 15th Amendment was not sufficient, why the Reconstruction statutes were not sufficient to protect the right to vote, given what the Supreme Court did to narrow them, and then taking us straight to bipartisan majorities, reenacting the Voting Rights Act with Bob Dole co-sponsoring it in 2006, with 1 million pages in the record saying we still have a problem. We need pre-clearance because each of these states that are covered are doing things to suppress the vote. And if we have to go to court and have federal lawsuits, it's not going to be in time for the election. And then the U.S. Supreme Court in Shelby County overturns that. I want to know why the Voting Rights Act is so important, why overturning it in your view is incorrect in Shelby County, and where that leaves us now.
I say two things changed in the American South: air conditioning and the Voting Rights Act. And we understand better how air conditioning works because we at least have STEM education. Now they're trying to stop what little history and civics education we have in some of the Confederate states like Florida. Armand, go ahead.
No, that's okay. Go ahead.
No, you go right ahead. I think
I'm just going to say the right to vote back in the 19th century, people thought that, and we've talked about this, that by 1870, the two key measures of protection were there that could overcome the history of slavery, and that was number one, federal enforcement, and number two, the right to vote. And the Klan and others realized they had to get rid of both of those if they were to succeed in overthrowing and restoring themselves as being in charge, restoring the old regime. Well, in the 1870s and 80s, the Supreme Court basically got rid of federal enforcement, and that paved the way for the 1890s. That's our chapter 3. that paved the way for the 1890s, which is in chapter 4, we call the Supreme Court and the counter-revolution. In the 1890s, the Confederate States came back and amended their constitutions one after another to get rid of the right to vote for African Americans. So right to vote has always been recognized as one of the pillars. It was taking away the right to vote was a pillar of a dual society, and bringing back the right to vote is a pillar of reviving or bringing us a one nation under God for all people.
So when they passed the voting rights in 65, why was that needed? Why was it so important?
Because
And then how?
previous laws had not worked, so they just they just took the bit between the teeth and created a new enforcement mechanism.
How is it that Justice Roberts and the Supreme Court in Shelby County decided they could overturn Congress's decision to protect the right to vote by statute?
Because they had 5 votes.
But what was their reasoning?
This is one of the most disgraceful
matter.
things. One of the most disgraceful things that I have seen. And I think Armand and I really got into, and Armand was able to find that.
Let me just break in. If you have 5 votes, it doesn't matter. That's what their theory was.
Well, Judge Roberts created out of whole cloth the idea of equal state sovereignty. And he quotes from South Carolina v. Katzenbach as his evidence in an earlier case, which is the case of Mudd v. Austin. And it's where he sort of sets this up and no one caught him. What he did, if you look at our books, he ellipsed the words out of what Judge Warren said, Chief Justice Warren, and it says the opposite. It's just the opposite, and no one caught it. It says there's no such thing as equal state sovereignty, except in the beginning. And then
the school paper has been expelled for.
Yeah, well,
so basically that's taking away Congress's power to enforce the 15th Amendment right to vote. That seems to have it backwards at least 2 different ways. Then what's Congress supposed to do once you have Shelby County?
well, Congress is supposed to step up with the John Lewis Act and the other acts, just like it did when Armand led the fight in 1982 for the renewal. But now can I give my 3 little lines, quick stories that Armand wouldn't let me put in the book because we beat up on people so badly? Can I?
Yes.
Yes.
Okay. All right. When Dred Scott was decided, the lower court judge used the excuse that if, in fact, at that time, normally he would have been by precedent found free. In South Carolina and Mississippi, they found in those circumstances, they were free. He says times are not as they were. Fast forward to 2013. What does Judge Roberts say? It's almost an echo. Times are not as they were. Then go to 2021, a case that we probably shouldn't have done this, predicted what they were going to do with Bronovich. And what does Judge Alito says? Times are not as they were in 1982. Do you notice a historical pattern of explaining how things are not as they were, always to the disadvantage of minorities? It really bothers me that this has happened, and it continues, because this is why they create this false history, because they have the 5, now the 6 votes, and they can do what they want to, but they should not be able to create a fake history because they believe in alternative facts, which are nonsense, and write a history that doesn't exist. We might not be able to do anything, but once before with Justice Hughes, he turned and said, let me see the evidence, and it turned the court around. That came down to the Warren Court and some of those bad. So evidence is so important.
Can you just close by telling?
Let me bring in George Orwell here, because this is where he really belongs, and we quoted him. And George Orwell had all these things in mind. The quote is, "The past was erased, the erasure was forgotten, and the lie became the truth." And that's what we have too much of.
Thank you so much, both of you.
Thank you, all 3 of you. Fascinating, and I'd like to listen another hour and a half, but We have to leave. I'm gonna have to leave the building shortly. Thank you. And Ruth, were there questions? Other than the ones that were asked?
I think Patrick caught them. Thank you. Yeah.
Mhm.
Next time, let me read the conclusion of the book to give people some hope.
I would be happy to. I will try to arrange somehow to have you back because this is fascinating.
Yeah, well, as you say, we have too much to say. And,
Well, there's a
I
lot
hope
to
you
be said.
recognize what a genius of an attorney and legal mind that Armand is. It's pretty amazing.
And what he's done for the country, honestly.
Cut the malarkey.
Thank you very much, both of you. I'm honored to be on this program with you.
So are we.
We have really
Patrick.
enjoyed
Thank
it.
you so much,
Thank
Patrick.
you, Detroit.
We write books to be read, and you have read it
Mhm.
so well. Thank you.
I'm looking forward to reading it.
Thank
I
you.
am also,
Thank you.
and thank you so much.
Yeah, and if people have
Thank
trouble
you very
finding
much.
the book, they can write me and I'll mail them one. For the price
Okay.
I paid.
Thank you so much.
Yes, thank you. Goodbye. Thanks to
Thank
everyone
you.
for coming this evening.
Yes.
Thank you.
for the
Thank you. It
opportunity.
was
We really
fascinating.
enjoyed it.
Mhm.